Hey, it's James, Father's Rights and Resources, hashtag how I got custody. If you have an attorney and your attorney has not done a deposition, there's no point in you having an attorney. A deposition is the number one tool that's available in a court action. For those of you who don't know or understand what a deposition is, your attorney, let's say you're a father, you have an attorney, your attorney sends a subpoena to the mother, which says, come to my office and sit there till I'm done with you. And in the conference room, you guys go sit down on that day that she's subpoenaed, and sit in the conference room. There's a court reporter there. They put the mother under oath, say, you swear to tell the truth. And then they type away at their machine. They create a transcript. You go to court or have a court case to eventually, in the end, the goal of court is to have a trial. Of course, the alternative to trial is settling out of court. But you're going to court. You file a petition or any kind of lawsuit, or a prosecutor files charges to take somebody to court to prove a case that you have against them. How do you prove the case? You bring some proof, you bring some witnesses, and then you attack the credibility of the other person. So a big part of it is to take testimony of people. Prove that what somebody says is good, is the truth or something that supports you, or to attack, the people who are against you. And, if you're a criminal defendant in a criminal case, then, you want to attack your accusers. So in family court, we always have accusers. Everybody's flying accusations back and forth. So if you have somebody falsely accusing you of domestic violence, child abuse, whatever, why would you wait until trial a year down the road to prove that they're lying? You're getting temporary orders. Maybe the mom got an emergency order at the beginning of the divorce. You got blindsided with it. Why would you not immediately take her deposition and destroy her credibility so when you have the return hearing or full hearing, you could tear her apart instead of going to court and it's your on the surface allegations versus her on the surface allegations? Why would you not destroy your credibility now? Why would you not take her? Everybody has these on the surface allegations. Oh, he's abusive and he's crazy. And then usually at a court hearing, you don't get a chance to question her. Like, what did you mean by that? Where do you get that from? How can you let me have the kids if you said that I'm a child molester, I'm a child abuser? Or, I just talked to a guy the other day. He was falsely accused with 4 different CPS cases. The mom accused him of abuse and molestation on different time, each one of those on different times. And then she let him have the kids for several weeks or months after, then made another allegation. So she's not acting like she really believes her own allegations. I can go in there and say that, but it's even better to say, why did you let me have the kid if I'm a molester? Do you really believe? Are you the one who called CPS? Yeah. Did you say that he molested the kids? Which one? How? Where? When did it happen? How do you know it happened? Oh, I know it happened. Okay, so you really believe that he was a molester? Okay, why did you let him have the kids alone for days or weeks at a time? Or if the person says, well, I was wrong, I heard wrong, one of the kids lied and said that. Okay, why'd you file another complaint to CPS? Or why did you withhold the kids at all if the kid was lying? You tear their credibility apart. And a deposition, you can make somebody hand over documents too. You could do a subpoena ducis tecum, which means bring with you, bring the thing with you, bring stuff with you. hand over, bring 2 years of tax returns, 6 months of pay stubs, or if you haven't been together for a couple years of pay stubs, bank statements, your retirement stuff, and any contracts with daycare, any evidence that they have that they would want to use against you at trial or whatever. Now, I have a few videos on YouTube about depositions because attorneys will say, oh, we don't want to give them a heads up as to our strategy. That's a stupid, incompetent, moronic excuse to not do a deposition. If you ask them a question and they give you answers that you can lock them into, it doesn't matter that they know the questions. You got the answer. Before that, you were in the dark. So the only person giving stuff away is them because you dug the answers out of them. See how stupid these jackass attorneys are? Oh, we don't want to give away our questions. If you give away the question and then they answer the question, they've already answered it. They don't have any advantage. Now you have an advantage because you know answers that you didn't have before. And then you could think of other follow-up questions to jam them up at trial with or at a court hearing with. Why would you want to wait? Like I said, if you get screwed right now because of that person's testimony and you're able to prove in a deposition that they're not credible, then you destroy their testimony and you can get that court order, whatever they testified to that leads to a court order that you're on supervised visitation because you're abusive. If you do a deposition, you can prove that you weren't abusive because they were lying. Why wouldn't you want to fix that now? See, these attorneys are stupid and retarded, and they don't want to put any work in. I told you guys in several videos, especially on YouTube, the attorneys get a big fat retainer. They fight one time for you maybe at a hearing, and then they jump through the hoops. You get a guardian ad litem, and they talk to the other attorney, and they make agreements and settlements and negotiation and talks. Yeah, let's get a guardian ad litem. My client agrees to a parenting evaluator, and the next is agreeing to you spend another $5 or $10 grand. For what? Other people to evaluate you when you already proved that, or you could have proved that everything was utter bullcrap. See, you're getting a guardian ad litem, you're getting a parenting evaluator because the other person's lying. If you do a deposition and prove that they're lying, why would you need a parenting evaluator and guardian ad litem? See, so some of you guys are not thinking about this. And then you're hiring these attorneys who never think about this because the attorneys are used to doing what they always do because they always do it. It's a big game for them. They get a big fat retainer. They fight maybe once. They jump through all this other stuff and they spend hundreds and hundreds of dollars emailing you back and forth, emailing the other attorney, talking and yakking and talking and yakking and meeting and filing stuff and sending interrogatories and all this easy work. And then they say, let's go to mediation. You sit down at mediation and they get, you sit down at mediation for 4 hours. If they're $300 an hour, that's $1,200 for you guys to sit around and talk about stuff you can't settle on. And all the attorney had to do was call the other attorney and say, hey, are you willing to settle on 50-50? No, no way. Hell no, blah, blah, blah. Or about 60-40? Nope. Okay, so it's closer to 70-30 then? Yep. Okay, I guess we don't have a deal because my client's not going to say, okay, fine. That's it. But they want to go to mediation and put on a show and talk about what you guys don't agree with, and then everybody gets, the mediator, the attorneys, get paid. And you just waste a day of your time, maybe miss a day of work. This stuff is freaking insane. And the fact that you guys, a lot of you guys, still pay the attorneys and lick their boots, and then you criticize me because I tell you the reality, like, wake the hell up out of your little stupor and living in the matrix and following everybody. And then people a year later go, oh, you were right, James. I didn't listen to you, but you were right all along. Dumbass, what? I've been doing this for 24 years. You're a freaking rookie. I show you my winning court orders over the course of years and years. My first appeal that I won, discretionary review, interlocutory motion, was 2004. I got a reversal in the Court of Appeals in 2012. So there's long gaps in me continuing to win. Anyway, if you're not doing a deposition, you're wasting your time and money on a whole bunch of frivolous bullcrap. Why do you have an attorney?